Hi, I am Michael Santos with Compliance Mitigation, and I want to thank you for being a part of our program. I don't know whether you're watching this just on a regular post on our website at compliancemitigation.com, you're going through one of our free trials, or you're a premium member, but what I would like you to know is through these case studies, you are going to learn how decisions on the job can lead to prosecutions for white-collar crime or government investigations, and we want to help people do better. So we're going to read today this post here, which is about violating the False Claim Act, and I'm going to tell you what happened. So a furniture company obtains various contracts from the GSA to fit out its offices. The work is provided over the course of 8 years while the company simultaneously grows its sales to the general public. Prices charged to the government sometimes exceed those prices that the company charges to its private customers. And this results in a whistleblower complaint and a government investigation. So this is important for anybody that works for a government contractor, because you really want to understand that although you can control the decisions that you are making, you really can't control the decisions that other people are making around you. And when that happens, if you don't have your eyes open to what's going on, you can get roped into a government investigation, which can bring just a parade of horribles that everybody wants to avoid. So in this case, we're going to learn a little bit about what happened to this company. So according to their author who wrote this case study, the U.S. government doles out more than $30 billion in contracts through the General Services Administration. Now, most of these agreements require competitive bidding, which can delay the purchase of products needed on a more timely basis. The GSA, therefore, also employs a streamlined process to procure more commonly used commercial goods and services. Certain products and services and just anything that the government needs. Now, provisions of those goods and services sometimes incur greater supervision than competitive bidding projects, especially with respect to price. And since selection of those companies is not subject to direct competition, there is more scrutiny over how the administrators work through those contracts and pricing schedules. So the government applies strict standards and a take-it-or-leave-it boilerplate language in contracts with most companies to which it gives business. The companies willingly accept the risks of these contracts in exchange for long and lucrative relationships with the government, a customer whose creditworthiness is beyond reproach. These contracts, however, are also ripe with potential liability. As our country's budget deficits continues to grow, we can expect greater pressure to rein in costs and also to generate revenues from government investigations. And one way to generate those revenues is by publicly prosecuting and exacting significant fines from people that abuse their position of trust. The whistleblower provision under the False Claims Act makes it easier than ever for prosecutors to bring cases. And the way that process works is, let's say that somebody is working for a hospital and the hospital is billing Medicare in a manner that is inappropriate. If that happens and there's somebody in the hospital that becomes aware of it, that person can bring a whistleblower action under the False Claims Act. It's also known as QTEM case. What that means is that the person becomes a relator, and in exchange for them bringing the case to the government, if the government chooses to prosecute, the individual who brings the case can get a significant portion of any of the resources that are recovered. And sometimes these fines can be measured in the hundreds of millions of dollars. So we see people from QTEM cases walk away with millions of dollars even after they give a cut to the lawyers. So the reason that people in businesses want to understand this is because if somebody's doing wrong in the company, there's going to be a series of problems that surface. And if you participate in our course Compliance 101, you will see that anytime somebody is either a witness to a government investigation or a subject to a government investigation, their exposure to problems really goes off the charts, because they're talking to people that have the power to bring a criminal prosecution. So in this case, I don't think there was a criminal prosecution. Let's go ahead and continue reading. So Workrite Ergonomics is founded in 1991. It's a company that pioneered the manufacturing and distribution of innovative ergonomic and space optimization projects for the workplace. Things like this chair that I'm sitting on right now. They produce keyboards with unique designs, adjustable sit and stand desks, and specialized monitor arms to provide for a more comfortable and productive office environment. Its parent company, Nape and Vogt, I don't know if I pronounce it right, Nape and V-O-G-T, Vogt, maybe, Manufacturing, has annual revenues in excess of $100 million and more than 500 people work in the company. It's owned by a private equity firm, Windpoint Partners. Now, all the information in this background we get from the Department of Justice's press release and related articles. So Workrite utilizes a team of designers and engineers to incorporate modern techniques, the latest technologies, and high-quality specifications, and they create products to serve its worldwide clientele, including the U.S. government. The company focuses on comfort and safety, believing that comfortable employees will be more productive and less likely to miss workdays due to injury or bad health. And this benefits the entire organization. Workrite products may be easily adjusted, making them highly adaptable to meet a company's specific needs or changing needs as business develops. Additionally, Workrite takes care to protect the environment and the health and safety of employees, striving to develop products and processes that use recycled materials and environmentally sound manufacturing methods. So, by all purposes, it's considered to be a good corporate citizen. They reward their employees. People are happy to work there. It's the kind of company that we would expect government to promote. But that doesn't matter. Just because a company does good in one area doesn't mean it can't become a target for either a civil investigation or a criminal prosecution. So we want to just be aware. You may be working for a great company. Just be aware. As the government says, they want to make sure that everybody on the team is kind of an ambassador for goodwill and good corporate citizenship. So if they see something wrong, the government expects somebody to say something, and they reward people to do it. Workrite provided office furniture to government entities from 2009 to 2017 through that GSA Multiple Award Schedule program. And that's that program that relieves it of the burden of solicited of sealed bids. The MAS program provides the government with a streamlined process to procure commonly used commercial goods and services, eliminating the otherwise typical requirement of government bidding. Workrite, like many companies, provides flexible pricing for bulk orders of its products. Prices may at times also be influenced by internal oversupply or the potential for additional business and other factors typically contemplated in conducting commerce. In certain contracts, Workrite fulfilled for the government between 2009 and 17, it charged higher prices to the government than it charged some of its private clients. And somebody brought this case to the attention of the government through the False Claims Act. His name was Michael Franchak. The False Claims Act, also called the Lincoln Law, is an American federal law that imposes liability on people and companies who defraud government programs, typically government contractors. It is the government's primary litigation tool in combating fraud against the government. The law includes, as I said, a qui tam provision that allows people who are not affiliated with the government, called relators, to file actions on behalf of the government. It's whistleblowing. You've probably heard of it. People filing under the act stand to receive a portion, anywhere from 15 to 30% of all recovered earnings. As of 2019, 71% of all FCA False Claim Act actions were initiated by whistleblowers. The case was taken up by the Department of Justice's Civil Division. The government alleged that Workrite did not fulfill its contractual obligations to provide GSA with accurate information about its commercial sales practices during contract negotiations. Further, it didn't extend lower prices to the government agency customers as the GSA's contract required. Workrite faced the prospect of lengthy and expensive litigation, along with uncertain consequences of potentially losing at trial. And for that reason, the company elected to settle the matter for $7.1 million. And Franchak, the relator received $1.27 million from those settlement proceeds. So here's our recommendation. Government contractors face a labyrinth of additional requirements when performing work for government agencies. Many of those people hold contractors to more stringent standards than apply to the private sector. Ordinary and usual practices such as price fluctuation must be dealt with differently due to provisions in government contracts. Companies also must be careful to monitor business conducted in other sectors and divisions to ensure that it doesn't run afoul of its government agreements. Government contractors also face additional exposure presented by the FCA. While all companies should strive for full compliance at all times, that goal is aspirational. No one is perfect. The FCA and its incentives initiative for employees to expose abuse with hopes of large paydays puts government contractors at higher risk of potential civil and legal liability. Any company engaged in government contract work should take extra precautions. It must be mindful of the risks associated and assess both the work to be performed and the follow-through on the execution of that work. Companies should also have the proper procedures in place to ensure compliance and minimize vulnerability to risks of government investigations. I would like you now, if you haven't signed up for our free trial, please do so that you can take the quiz at the end of every one of these case studies. You'll end up getting a certificate, assuming you pass the test, with a QR code so that we can validate you as somebody who's committed to compliance and hopefully lessen your company's vulnerability to a government investigation. Thanks.